Hello, this is Dave Zook again. I think that my sales pitch was mildly incomplete. So I want to just abbreviate it by appending this thing about facial challenges. I want to present a facial challenge. I want the judge to understand that in this case, that what we desire is a facial challenge to Fort Collins City Ordinance 17181, which, by the way, imports itself into 17182A, which, by the way, has no home interior exclusionary clause, has no reference to curtilage, has no reference to anything like that. So it essentially makes it illegal for anyone to camp within their own home, except for if they live in a trailer park, in which case they'd be subject to 17182B, which immediately gives rise to a huge equal protection argument. And there's another equal protection argument that the homeless can use as well, because although 17182A is enforced, it this is totally unclear to me as to whether it's enforced in the proper way according to the way the law is written. Because it has no home exclusionary clause, it makes it illegal to sleep within one's own home, or to spend the night in one's home, or to reside or dwell temporarily in one's own home, or to perform activities of daily living within one's own home. But anyway, getting back to the concept of facial challenges, um, the, the, there's a professor, a Harvard professor, a very well known one, who is an expert on facial challenges. And he's written three seminal, or important rather, papers within the last 20 years on facial challenges. Now, as an aside, his name is Professor Fallon, by the way. As an aside, the case, I don't remember the guy's name, but it was a cruel and unusual punishment argument made by the city of a homeless person who resides in the city of Denver, was negated. Well, was first was first this argument was approved, then it was appealed by the city of Denver, and there's a judge who used Salerno to negate it. So, I mean, there's ways of avoiding Salerno, but I don't even see the point here. First, let's talk about Salerno itself. Salerno was used in the Bail Reform Act of 1984, and it wasn't used for the entirety of the act. It was only used for a part of the act. So, in the words of Professor Fallon, he calls that separable. Uh, the judge severs it. Obviously, not all laws are severable or separable, although the SCOTUS presumes that they are. It seems to operate under this presumption, as noted by Professor Fallon. Um, if you have a law, if you're into science and math, computer science and stuff like that, it's trivial to come up with a law that is not at all separable. And in actuality, it's not even diagonalizable in terms of, like, if you look at it in terms of quantum states, you have a complete sort of quantum mechanical entanglement between these laws. Say you have a law with four clauses, say three clauses, to make it simple. So if clause one depends upon clause two, which depends upon clause three, which depends upon clause one, they can't be entangled. This law is not separable in the Fallon sense. So, but getting back to Salerno, the initial case, Salerno itself was not used on the entire Bail Reform Act. It was only used on a part of it. Now, This whole thing with facial challenges arose after Robinson v. California in 1962. It seems to be a product of the early 70s. This whole concentration on facial versus as applied, and of course, every case is as applied, right? But I mean, many cases are both. The Professor Fallon and his students did a study, and they found that the Scotus's proclamation about the profundity of as applied challenges relative to facial challenges is simply not true. And Scotus has adjusted since then. That paper was written, I believe, in 2009. So now it's recognized by Scotus that as applied challenges, I mean, facial challenges are at least as common, according to Professor Fallon, as applied challenges. And not only that, the probability of success is greater as measured by him when he looked at periods of time separated by 5 years, dating from 1985 to, I don't know, it was around 2010, I think, when he did that study, for full year of Scotus cases. So at any rate, just generally speaking about what I meant by declarative and injunctive relief is not for me. Although I haven't mentioned, this is just a sales pitch. I want to also include 17182B, and my argument for including that would be probably frowned upon by most judges. But the thing is that the whole 17181 is just not understandable unless you analyze it textually. So unless you use, Supreme Court precedent that says, give import to, like you become a Scalia textualist, give import to every word. Every word has meaning. No words have no meaning. So you just read it as plain language and interpret it suchly. And that is the judicial construction that I want to use. And if I want to argue that by doing so, you'll see that camping has nothing to do with camping. Camping, these two camping words, what I mean is colloquial camping. The reason is that colloquial camping, in every dictionary you'll look at, is defined by way of camp. Camp is first defined, and then camping, what it means is to occupy a camp. So the definition of camping, colloquially speaking, is to occupy a camp. Okay, camp is something that's fixed relative to the earth. It's a fixed GPS location. Okay, well, how is camping defined in the city of Fort Collins? Well, camping is defined is the exercising of a verb, one of 4 verbs: to sleep, to spend the night, to reside or dwell, or to perform activities of daily living. Where? At such place. What is such place? Well, such has us look for places previous to the such mentioned in this. And there is only one place, and that is public property. Well, is camp defined anywhere in the camping section or in the definition section as a prelude to the camping section, section 17X and miscellaneous of the Code of Fort Collins? The answer is no. Camp is simply completely undefined. What is a camp? Well, I guess we have to work backwards. Let's propose this reasonable definition of camping. Of a camp. A camp shall be a place where camping is done. Okay. If we use such a definition, what we'll see is that there is only one camp in Fort Collins, public property anyway. And where is that? It is such place. What is such place? Well, if you're in 17181, such place is public property. Why the terminology? It's really a Udall way of importing. By this, I mean, like in a computer science sense, of using the same kind of code and importing it into another section of the law, and it is imported into 17182A, in which case such place is public property, private property. So there's two camps in Fort Collins. One is public property and the other is private property. Okay, so, and by the way, as long as I'm on this aside, what does camping mean in 17182? What is the legislative purpose? Well, it wasn't published for having 17182 be separate. It wasn't published, but I have a memo, an inter-office memo, which said that the previous law made it illegal to occupy an RV, and they wish to correct this. That means that it made it illegal, and this word was used as well, to be in an RV. So the desire to make it legal to be in an RV was prevalent, and so they made section 17182B, which makes and it defines camping. It doesn't actually say camping is defined suchly or anything like that, but the intent for a definition is obvious. Is camping is to occupy occupy a vehicle for the purpose of living or sleeping. So if one wishes to have the same connotation for what camping is in 17182A and 17182B, then one must be forced to the conclusion that camping is living, right, or sleeping. Okay, well, what is camping in 17181A? Well, it's the same thing as defined in 17182A. It's the same as defined in 17181. So if we wish the uniformity of definition and throughout the entirety of section 17X, what we have is that camping means living. So it makes it illegal. Making it illegal to camp makes it illegal to live in Fort Collins. So, excuse me. Anyway, getting back to Salerno. Well, Salerno in the Bail Reform Act of 1984 was used not on the entirety of the act. It was used only on a small section of the act. Now, the pronouncement of Rehnquist in Salerno was something like the set of all circumstances. So something like that. So a law, by the way, there's other forms of facial challenges, but if one is talking about a Salerno type of facial challenge, as the judge in Denver imposed upon the Martin Boise argument there, Martin Boise type argument, excuse me, what we're talking about is the set of all applied cases, right? Now, I have a math and physics background, so I did graduate work in both. What SCOTUS must mean here is not the set of all possible circumstances, right? Because first of all, that's ill-defined, and one could use one's imagination to fly to the stars and to discover all sorts of circumstances which may be theoretically possible. What Rehnquist must have meant was the set of all actual circumstances, the set of all applied cases. Okay, this is my interpretation, but whatever. Of all extant applied cases. Okay, well, how do we deal with that? We just deal with it clause-wise, because in order to be camping, one has to trigger one of four clauses: to sleep, spend the night, reside, or dwell temporarily, to perform activities. So if one does not trigger any of the four clauses, one is not camping. So one analyzes them one clause at a time. The first one is Salerno Zappo out already because bodily integrity. Okay. The second is First Amendment, right? Violations. And also, we're talking about a post convictive kind of punishment used for sex offenders. It's a temporary banishment from the city. Okay. The third one, as I said, no one knows what the hell that means. That's to reside or dwell temporarily. It's totally vague. I've used the meaning to loiter. So I use case laws. There's a fundamental right to loiter in the state of Colorado. It's a fundamental right. What one doesn't have in the state of Colorado is the right to loiter for the purpose of X, given sufficient and good set of X's, right? It is legal for people in this for cities in the state of Colorado to make laws which make it illegal to loiter for purposes of certain X's. But it's not illegal, or it's not legal for the cities in Colorado, even home rule cities like Fort Collins, to make it illegal to loiter everywhere, right? For no apparent reason. That now apparent reason is actually used. No apparent purpose. Sorry, that's another famous Scots law, but it's not legal for them to do that. And as interpreted that way, which of course I don't have the power to do, but what else are we supposed to do? That one gets shot out of the barrel right away like a fish. And okay, and like certainly with the third clause, we need to the city and I or we need to come to some agreement as to what the hell it means. We could use void for vagueness and overbreadth too, because it is incredibly vague and it's meaningless. Okay, now the fourth clause, activities of the now I could use 18 U.S. 241 and 242 because these are federally protected rights, right? Not the rights that I have, but that's not the condition required. I have an argument for that too, but I mean, I have arguments up for the zoo. But the thing is that we can shoot the fourth one out too. So, in order for a Salerno to be met, the set of all circumstances, the set of all extant applied cases, in order for these to be applied appropriately and judiciously, in order for a person to be found guilty, they have to trigger one of these clauses. So we can pick it apart using Salerno. But due process is in of itself, at least according to Professor Fallon, an as applied challenge. So what I meant by injunctive and declarative relief, I meant not just for me as applied, I meant for every homeless person in the city of Fort Collins. So what I mean is the complete eradication of 17-181 and 17-182A. And you can have some fun too with equal protection if you like, by playing around with the fact that people who live in trailer parks have the right to camp, to sleep, spend the night, whatever, in their own homes, but people who live in homes don't have this right according to the textualist interpretation of the law 17-181, which is imported into 17-182. But like I said, camping, maybe I didn't make this clear, camping is a technical term, a plain language technical term, because there's no way to understand it otherwise. One must apply the plain language of the words, all of the words, in a textualist way, else one gets complete absurdities. One gets thousands of possible sub-interpretations that one must deal with. That doesn't give fair notice to anyone. So, okay, that's just what I wanted to add. Thank you. Have a good day.